What are the different types of custody? In Georgia, there are two types of custody. So it's legal custody and then it's physical custody. So legal custody, that relates to essentially who would have legal rights to the child. It would be as it relates to who would get medical records for the child, who is able to access educational records for the child. That's pretty much always going to be a joint 50-50 joint legal custody, which means that both parents have equal legal rights to their child. The very little circumstances that I see where joint legal custody is not awarded would be very extreme. For example, one parent is incarcerated or they may suffer from some sort of addiction. But for the most part, it's going to be joint legal custody. As it relates to physical custody, that relates to what parent has the child physically most of the time. Now, physical custody could either be joint physical custody, which means that both parents share equally who has custody of the child, or it can be one parent is a primary physical custodian, which essentially means that the child is just with them most of the time. What is the best interest of the child is the legal standard that the Georgia courts go by to determine what rulings they should do. And it literally is what it says. What is in the best interest of the child? So it's basically this umbrella term that all of the questions are going to be led with whenever a case goes before the court. If there's an argument as to which parent should be the primary, the leading question is always going to be, well, what's in the best interest of the child? If the question is, well, who should have final decision-making authority as it relates to education or extracurriculars, the question is always going to lead with, well, what is the best interest of the child? So under that overarching question, there's going to be a lot of smaller sub questions, as I like to say. So it might lead with, well, what is the best interest of the child? So say, for example, we're looking into, well, who is the best primary physical custodian for the parent? So after that question, you might ask yourself, well, who frequently gets the child up and ready for school? Who gets the child ready for bed? Who prepares the child's meals? Who's in touch with the children's teachers? Who goes to the pediatrician? So these are all these little subsect of questions that would all fall under what is the best interest of the child. So say, for example, you have an existing custody order because say you got a divorce or a legitimation. What happens if for whatever reason there's a circumstance and you want to change that? What is that called? What do you need to do? In circumstances such as that, you would need to file what's called a modification, and it would be a modification of whatever order that you wish to be changed. So say, for example, that you have a divorce and you were awarded primary physical custody of your child, and the other parent was awarded every other weekend. Let's say, for example, that that parent, for whatever reason, has not been exercising their parenting time. So you have been exercising more than what is in the parenting plan. In that case, you may want to do a modification of your parenting plan. So you would file a modification of that parenting plan, and you would essentially outline the facts and the circumstances that have changed since the original order that would make a judge say, hey, let's change this plan because these circumstances have occurred, and a new plan would be in the best interest of the child. Now, typically, you can only file a modification once every 2 years after an order is issued. However, if you can show that there has been a substantial change of circumstance, then you may be able to file an action prior to that 2-year period. One of the most common examples of that is if both parties were originally living in the same state, but say one decided to relocate out of the state to, say, Alaska, then that would be something considered a substantial change of circumstance, and that would be something that would trigger a modification prior to that 2-year period. So if there is a current existing custody order, but say that something's occurred and you're just not happy with it, it could be something as simple as you feel like the co-parenting just isn't working, that they're not communicating with you. Is there something that you can do? Now, if the change that you are concerned about is before 2 years, then you likely would not be able to file for a modification because a judge would not deem that as substantial enough. But if 2 years has passed since the issuance of the order, then you would be able to file a modification at that time based on whatever concerns you may have. So one question that I commonly get is, can a parent decide to relocate out of the state with their child? And my answer to that always is yes. There's no restrictions on if a parent wants to relocate out of the state, right? Because at that point, you're kind of trying to restrict freedom of movement for people. And that's just contrary to really American law. What I will say is that there is a standard provision in a lot of parenting plans where both the parents would need to provide notice to the other. And it's typically within 30 days that they do have an intention of moving, and they need to let the other parent know where they are moving as well as providing an address. And then in those circumstances, if you are notified that the parent is trying to relocate a substantial distance away, then that would open up the grounds for you to file a modification. So if you have any additional questions as it relates to child custody, child modification, child parenting plans, or anything of that nature, feel free to reach out to us here at Daniels and Taylor.